Ladies and gentlemen, I welcome all to my channel. Today, let us see the classification of contracts. The contracts, the agreements which is enforceable in the court of law is called contracts. In traditional way, in ancient time, the contracts are classified into three categories. The first category of contract is called contract of record. The court's judgment, recognized orders between the parties are all called the contract of records. The second type of classification is contract under seal. The contracts, the agreements or contract which is signed and sealed by the parties are called contract of records. All the other contracts are called as simple contracts. So in traditionally, the contracts are classified into contract of records, contract of seal, and simple contracts. Another classification of contract is based upon the conduct of the parties. Under this category, the contracts are classified into three categories. One is called express contract, the another one is called implied contract, and the third one is called quasi-contracts. What is meant by express contract? If the parties have defined the terms and conditions, and all the terms and conditions, all the conditions, all the considerations, and all the dealings between the parties are clearly defined and expressed in the written agreement, it is called express contract. Implied contract is a contract where the contracts shall be presumed or implied from the contract of parties. Supposing you are going to a hotel and taking a tiffin, then it is presumed that you are going to pay the price. If you are going to an advocate or doctor for consultation, the conduct of the party will presume, it will imply that they will pay the fees, they will pay the price for the food supplied. So the contract of parties, the contract can be implied from the contract of the parties. This type of agreement is called implied contract. The third one is called quasi-contract. It is a contract imposed under the by law. Supposing if you order a food in Swiggy by a flat B, and the Swiggy staff wrongly delivered it to flat D, then the flat D person who received the food has to pay proper compensation, proper price to the Swiggy for the supply of food enjoyed or taken by him. Supposing by mistake the good is delivered to A instead of B, the person who received the goods has to return it immediately, or otherwise if he has consumed it or taken it, he has to pay proper price to the supplier. This is a contract called this is a contract which is created by law. So this type of contract is called quasi-contract. Then the contract is also classified upon the obligations. Supposing in the contract, supposing there in a contract, supposing person A wanted to construct a house and make a contract with the builder, then here the obligation, supposing A paid the price to the house and the builder has to construct the house and deliver it to the owner. Here the obligation of the owner of the building has completed. The obligation of the builder to construct is pending. So this type of when there is a obligation is pending for one side, it is called one obligation of the one side party is performed and another party is pending, then it is called unilateral contract. And in a contract where the obligation is pending on both sides, then that type of contract is called bilateral contract. For example, suppose in the building agreement, if you are making an agreement with A makes an agreement with the B to construct to construct a house for a sum of rupees 50 lakhs, and A did not pay any amount, and the builder also did not commenced his construction. Here the obligation is pending on both sides. This type of contract is called bilateral contract. Another type of classification is called void contract, voidable contract, and unenforceable contract. Supposing in a contract, a contractor is made with the miner to purchase the miner's property for a lesser price. The miner may, on attaining majority, may say that avoid the contract, saying that I am not interested to continue this contract because the price is less. Like that, he can avoid or cancel the contract. Similarly, in some certain circumstances, supposing there is an agreement between an advocate and his client, or an agreement between doctor and his patient, an agreement between an auditor and his client, and in these cases, the advocates or doctors and the auditors are maybe in a position to dominate, control may have eminent control over his clients or parties. So in that case, if any such agreement is made through influence or like that, the agreed party, a client or patient may avoid the contract, saying that he was in his influential position when the contract was made. But in that case, the advocates or doctors or the auditor who are in a controllable position cannot avoid the contract. So the avoid permission is given only to the agreed parties like patients, clients, like that. So he can patients and client can avoid the contract, but the advocates or clients, auditors, doctors cannot avoid the contract because they are in a controllable position. So this type of contract is called voidable. So a contract which can be avoided by one party, which is permissible to one party to avoid the contract, is called voidable contract. The contract, another contract which is void contract means it is totally unenforceable. Suppose if a contract is made for illegal purposes or any which is not enforceable in the court of law, that type of contract is void ab initio from the beginning itself. So such type of contract is called void contract. Unenforceable contract means a contract which is not enforceable in the court of law. Suppose there is an agreement between two parties and it is supposed for any law or any change of situation, such contract could not be enforceable in the court of law. Such type of contract is called unenforceable contract. Supposing there is an agreement to supply for liquor for 6 months or 1 year period, and suppose a government has passed an order banning the supply of sales of the liquor, so then in that case that agreement cannot be enforceable in the court of law because of the prohibition imposed by the by the government. So such type of agreement is called unenforceable contract. And the last type of contract is called illegal contracts. So suppose in Indian Penal Code there are several acts are mentioned as a crime. So supposing an agreement was made to conduct any crime punishable or prohibited under the court of under Indian law, such type of contract is called illegal contract. So these are all the various classification of contracts. I hope this classification of contract will be very useful to the students who are studying law or BCom, and I hope you will be understanding the various types of classification of contracts, and the students who watch this video may give you a comment about this lecture, and I will try to improve my lectures in the further videos. Thank you. Goodbye.